Good afternoon, everybody. Welcome to our third panel, Concerns in Receiving Large IRS Employee Retention Credits. For those of you who don't know, my name is Seth Kossman. I'm a tax attorney at Baker Donelson, dealing with individual and businesses having issues with the IRS. Before we start today, I'd like to take a quick poll of the audience just to gauge who's here today. How many of you of your businesses have already claimed or filed for the Employee Retention Credit? Great. Looks like people are shy. How many of you have not yet filed but are contemplating or planning on doing so? All right. Now, we have a lot of material to get through today. We're going to hold the questions and answers till the end. Our panelists have graciously agreed to stay afterwards and help us through any individual questions you may have. To set the stage, we're not here to talk about how do I determine if I'm entitled to the credit. I filed for the refund credit months and months ago, still haven't received it. What's taking so long? We're not here to talk about how do you calculate the aggregation rules or the full-time employee rules. We're here to talk about, I already filed for the ERC, and I'm having some second thoughts, or maybe I should be having some second thoughts. So with that, let's introduce our panel today. On my far right, we have Tom Bishop. Tom is currently a managing director at BDO Forensics. He provides forensic accounting, investigative, and litigation support to attorneys and clients in civil and criminal tax controversies, as well as white-collar financial criminal defense. Prior to his private sector experience, Tom spent more than 2 decades at the IRS Criminal Investigation Division, where he ran and helped provide executive-level leadership to its largest field office in New York. Tom retired in 2016 as a director of internal field operations overseeing global operations. To Tom's left, we have Stuart Schabes. Stuart's a colleague of mine, highly experienced tax attorney with Baker Donelson. He represents clients on both a domestic and international level on a myriad of tax planning and tax controversy-related matters, including extensive representation for the civil and criminal division of the IRS. As a result of the CARES Act, Stuart has handled numerous complex matters under the Employee Retention Credit, as well as interacting with the authors of the IRS who authored the guidance over the past 18 months. And finally, Ahron Golding. Ahron is a tax attorney at Roth & Company. He enjoys fighting the IRS and helping people resolve their tax problems so they could sleep better at night, rather than lay awake listening to tax resolution commercials. Many of you might recognize Ahron from his popular and informative webinars regarding PPP and ERC. Now, the way we're going to structure this today is we've all fielded questions over the last year and a half plus from individuals like yourselves, and we've put together a list of what seems to be a common recurring theme. I'm going to act as if I am the owner-operator, and these are my 3 professionals here who provide me valuable advice. And I'm going to throw out some questions that I've had, and if you guys want, you can feel free to listen in. So let's start in the beginning. Congress extended the statute of limitations from 3 years to 5 years. It's pretty unusual for them to do such a thing. What's the practical effect of that extension, and why do you think they did that? Tom?
Well, I don't think I can recall a statute, and Stuart and Ahron comment if you want, that they've had a 5-year statute of limitations. It's normally 3. In my days in the criminal division, it can be extended to 6 years. But making it 5 was interesting. I think at the end of the day, Congress thought, let's try and pump as much money into the economy as we can. Let's just get it out. They didn't do their normal due diligence on the regs and the guidance that they wanted to issue. And they had to build in some time to be able to go back and sort of look at things from a much higher vantage point and look for, obviously, the mistakes and the errors, because this is complicated stuff, and that's why the owner-operators out in the audience and other folks will hire professionals, because it is complicated. And for me, it's way above my comprehension level. So I let the real accountants do that stuff and figure it out, because it is quite complicated. And the same goes for the IRS, right? The IRS has got to learn this program too. They don't write the laws. They help determine the guidance and the regs. So you get into that sort of evolutionary phase where this is just starting and it's new for everybody. And I think in the IRS perspective, it's that process, and they want it to be successful. But this is being dumped on them, additional stuff from Congress to try and enhance the economy and get money back into the hands of the people that need it. So what it does is it just gives the IRS extra time to be able to go back and look at it, which maybe sounds like a negative, right? Because it just gives them 5 years as opposed to 3 to come back and audit and check and make sure that they understand what happened. When we were dealing with the criminal side, we would get these referrals in instances where there was fraud, and I wouldn't expect anybody out here to have that concern, but we always were worried about that 3-year statute, and we had to make sure we preserved the ability for the IRS civil side, should we not go forward, to go back and make the assessments and the necessary adjustments. So I think that they actually thought out and maybe did that because of they did anticipate the confusion and they did anticipate some fraud, but they also needed to give the IRS, I think, the ability to learn, and the learning curve on this is probably going to be fairly steep. It's going to go up and then it's going to level off, but the IRS has to figure out what they're seeing, what they're noticing from the filings going in. So
basically, as the business owner, normally I just had to hold my breath for 3 years. Now I have to hold it for 5 years, is what you're telling me.
Until you turn blue. Yeah, but the other good thing about the what seems to be maybe a negative in terms of getting audited, it also allows for you 5 years, should you want to go back and take the credit, right? So it does work both ways. Once you've figured out, maybe, there's a lot of myths and a lot of misinformation just because people don't know about whether you qualify, don't qualify, whether it's something you can do or not do. And you probably talk to 10 different IRS people, they'll tell you 10 different things, along with professionals who, this is a cottage industry now, where people are leveraging this recent thing. And again, nobody really knows until the stuff gets litigated, and people are taking more aggressive positions than others. So, but it does give you some time. And Seth, don't hold your breath that long.
All right, fair enough. All right, so I heard that the IRS pre-reviews any ERC request over $100,000. And my ERC was multiple times that, but I already received it. I got it back. I got the refund in my account. I got the refund check. So does that mean that they already audited me and approved of my requests? Stuart, am I safe?
Hi, good afternoon. It's indeed a pleasure to be here. No, it does not mean that you were technically audited. The IRS does not open up a module on their computer system that says it's being audited, but there's several steps to the process. And much of it really is driven by whether it was an e-filed, timely, or an original return as compared to an amended return. What happens is that the IRS was instructed by Congress, get the money out. And again, these things evolved because, note, if you look at the differences between the way the ERC was specifically structured for 2020, it was much more liberalized for 2021. And therefore, what ended up happening is that the upside potential was significantly greater. So what the IRS did basically is, as soon as they were e-filed, they quickly looked at them. That's in contrast to an amended return. On the e-filing, they just wanted to make sure it made some sense. However, and that's why they were turning them around usually within 6 to 8 weeks. Sometimes it was a bit faster. As it went on throughout the year, it really lagged more. However, when you have a hard filing, that's where there's multi-tiered of IRS analysis. But it's not an official audit. What happens is that anything over $100,000 of a refund per quarter gets pulled. It goes to, they call it the fraud section, but it's not the usual fraud section. But instead, what they're doing is they're comparing the amount of the employee retention credit claim as compared to the wages that have been reported in past periods. And therefore, they're going to say, does this at least make sense? They are not at all looking at qualification, because as all each of you know, you don't have to say why you qualify when you submit it. All you have to do is say that I'm entitled to it. So the short answer is no, it does not mean that in fact they've been audited, and therefore that's one of the reasons why, getting back to Tom's comment, they built in plenty of time. I mean, right now, the IRS hasn't even begun to put together the manual of which they're going to use to audit these things. But again, it's something to stay tuned on.
So I passed the sniff test, I guess is what you're saying, that it's not so bad, but it doesn't mean I could stop holding my breath.
That is correct. That is correct.
Seth, just to jump in quickly, the IRS, if anyone's seen anybody from the IRS speak lately, they'll talk about data analytics, artificial intelligence, and this is all part of the process. They've developed algorithms and different ways of approaching the numbers, and then they mesh all of the information the IRS has on the various companies. They kind of know the numbers of employees, the amounts of wages based on the industry, based on the area of the country. And they can just spit this into one big computer and let it just run through it. And it's this cursory check using these new technologies that come out all the time. And they've spent a lot of money on their budget in developing these programs for whatever compliance area they're looking at. So, they could just fine-tune it for nursing home work or accounting firms, right? So they can do it however the parameters are set. They just are gaining much more functionality in their AI space and their data analytics, hiring data scientists.
And just buttressing that, what ends up happening is that typically they will look at not just the returns, but also the PTINs to see which preparers have been involved with this, and then if they start to see that there's some issues, that will then open up a total different panoply of interest by the IRS.
Great. All right, thank you. All right, Ahron, question for you. I have nothing to worry about, I don't think, because my ERC wasn't that large. Now, granted, I have over 10 entities that I'm filing for, and in the aggregate, I received a lot of money. But why should I have any concern? The IRS doesn't have the resources to audit me and each of my entities.
That's a fantastic question, Seth. I will tell you, you have nothing to worry about.
Man.
As Tom just mentioned, recently the IRS has discovered this thing called a computer, where they can actually find things that, shockingly, they actually are able to be some level of technologically advanced. Not a week goes by where I am not surprised by something that the IRS seems to figure out. And I have conversations with the auditor, and in a sensitive way, I sort of ask them, how did you know that? Or stuff like that. The data analytics has gotten pretty good because they don't have funding to do anything else. So, I wouldn't say there's nothing to worry about, because if people have aggregation issues, that's just one of the easiest things for the computers to pick up. So that's something that is a question that not a week goes by that I don't get. We're not supposed to give advice based on audit risk, but the IRS has computers now. So.
All right, so I'm starting to get a little nervous from you guys. If the IRS does come after me, what's the worst that could happen? Meaning, I've been through audits in my company before, and I've paid additional tax, interest, penalties, what have you. But that was kind of the end of it. Why would this be any different? Tom, coming from the IRS, is this like any other audit?
Show of hands, how many people have gone through audits? It's not a fun thing, right?
How many people want to go through an audit?
Yeah, that's a better question. How many people really want to go through an audit? But, I think, and I get into this area a lot when there's sort of these funky audits where there's some issue in the background that we're trying to smooth out. I think that, most people, when you're in business, you're going to look at this as a risk of doing business, right? The cost of doing business. And accountants and individuals, and they get together and they take positions on tax returns. Some are more aggressive than others. And in the back of your head, you're thinking, well, if I get audited, I'll just have to pay. But, here's the opportunity maybe to maximize or optimize my tax position. And then here comes the audit 3 years later, and you can't remember what you talked about, and everyone's going through their emails, and fingers are pointing between you and your accountants. How did this possibly happen? That's just the cost of doing business. And this isn't any different than that, right? This is not going to change the focus there. I think we don't know how it's going to happen, right? Because, again, as Stuart mentioned, and the manuals have not even been drafted, to discuss how we're going to audit these things or what they're going to focus on or what the information document requests are going to look at. But I think the issue, I think, in my mind, and I'm a little skeptical coming from the criminal division and where I spent most of my career, these programs where money goes out are those that they have to look to make sure there's integrity in it, right? So they're going to look at some point for the fraud, right? And now we're talking about not paying the cost of this with money. We're talking about your freedom. So there's this sort of notion in the back, and nobody, I think, goes in, well, I shouldn't say that. People do go in taking very aggressive positions. Let's hope that it's not based on fraud or anything like that. But if there is fraud in this, and there will be fraud somewhere, we all know that. It's bound to happen. Just like, when the PPP loans were coming out, and the only thing you saw were people that would go buy $1 million boat or a Maserati, and then the next thing you know, the FBI and the IRS and everybody was picking them up. And that's the low-lying fruit. I mean, that's the the greedy ones. And I used to tell people, we didn't catch the smart ones, and sometimes we caught some stupid ones. We caught the greedy ones. And when people get greedy like that, I think this is a little bit different because it's more technically sort of complicated than creating a phony loan application. But then again, maybe not. Maybe someone goes out, starts the LLC, claims they have all these employees, blah, blah, blah. The next thing, the IRS is, marching somebody out in handcuffs or, prosecuting them and publicizing the heck out of it is what they would say, because they don't have the resources to go after everybody. So they're going to hit that example, and they're going to hit it hard. So don't be that example. That's my advice. But this is why it's different. It's a program that spits so much money into the economy, and that's what they're trying to do, stimulate it. And when they come back around to reviewing it, we'll find some of that fraud in there.
I mean, don't forget, one of the lesser focused parts of the employee retention credit is to the extent that the IRS believes that you shouldn't have taken it. What ends up happening is that it's a liability. But what they do is that they will undo the amounts that have been credited, which opens up the opportunity for the IRS then to look at assessing a trust fund recovery penalty. Now, granted, there are defenses for that. But at the same time, if there are abuses being done, then that's something you have to also balance in the equation. Now, please understand, that does not mean that people are not entitled to employee retention credit legitimately, but you have to know where to draw that line.
I just want to also mention from a mathematic perspective, for people that thought there's no way for them to get audited because there's not enough resources, which is true, but for the PPP, if you take a look at the math, the people that are really running the PPP and would have to enforce it are the SBA. They don't have trained auditors like the IRS has. So if you take a look at the amount of money and the amount of PPP loans out there and the amount of SBA auditors available to audit, there's about 1/500th of the amount of chance of getting audited as opposed to the ERTC, which is going to be handled and enforced by the IRS, which has better trained auditors and just less ERTC being taken. So just that's the way the math works out.
I want to jump in on this, Stuart. You had mentioned it. And Stuart said, if you're entitled to take it and you qualify, certainly take it, right? You want to do that. And what Stuart brings up is a very interesting thing about the trust fund recovery penalties. And he and I have some experience on some real good ones. I see my friend Tom out there. He's part of it too. But even civilly, these things are assessed against a responsible party within the company. And that can be the IRS has a very liberal view on who's responsible. And it can oftentimes go all the way down to just an accounting clerk with access to the bank accounts who's stamping the checks or making the direct, the payments of salary. And that becomes difficult when it's 100% of the penalty assessed against you personally. And I think that is something to consider, not as a reason to discourage anybody from taking it, but just know that the IRS will look to do those things.
I'd say because this is so new also, what we see in these type of situations is the IRS, DOJ are looking for the press release. They're looking to get somebody, and they don't even care who it is, small mom and pop, somebody who owns one nursing home. They're not looking for the big fish right away, but they want their press releases. They want to get out there that people be careful. And those are the risks that something like this would happen more than other cases. Okay. So it sounds like I do have some risk, maybe 100% of the risk actually as the owner. But how about this? I hired an accountant and an attorney to file the ERC for me. And they walked me through it. Math was never my strong suit, and when it comes to math, they were explaining to me how they calculated the credit. I just got a headache, my eyes kind of glazed over. I'm like, all right, guys, that's what I'm paying you for. So I had my accountant and my attorney do it. Why do I need to worry about exposure? It's not my headache. Ahron, is it my headache?
As an attorney who works for an accounting firm, I will say I love blaming anybody that I can to get my client off of a penalty. And I've gotten $1 million of penalties abated because of blaming anything from another person to Hurricane Sandy. We're still blaming people on that. You know, we're not even up to the COVID-19 yet. But when we finish with Sandy, we'll
live out like out west.
Yeah, exactly. You get really lucky if the IRS person who is dealing with the penalty abatement had his home flooded due to the hurricane himself, which I've had. So the bottom line is, as the courts have stated, and we all might internalize deep down but don't really want to admit it, the bottom line is the taxpayer is taking responsibility for anything that's on the tax return, and a person has to know that. So even though when things get more complex, it's easier to blame the accountant, but just for me to say, oh, I hired some guy that was advertising on the internet, I'll take 35% of your ERTC. The government has your money, you know, come take the money that they owe you. You know, we're all for taking every dime that you deserve, but the bottom line is the responsibility belongs to the taxpayer.
But if I can embellish that for a minute, it's very interesting because the fact pattern as presented was you have an accountant and a lawyer. But if you understand, when it comes to these types of areas, the privilege and maintaining the privilege is of utmost importance. And what happens is that if the accountant doesn't have the cover in the industry because of a certain case law that developed in the 1960s, it was called the Koval decision. And because of that, if the lawyer hires the accountant, then the work papers can be protected. The issue, however, becomes one is once it memorializes itself on the tax return. So you've got different layers and different things to be concerned about, and then the question really becomes one of what's the government entitled to see? You know, and there's been a fair number of cases that have evolved over time now that are specifically trying to reduce the forcefulness and the protectionary device of the attorney-client privilege. So it's something to be careful about because it's not the kind of thing, because once you send it out into the general public domain, you've lost that privilege. And it's something you have to, the clients, each of you have to be very, very careful about.
So signing under penalties of perjury on a tax return really counts for something, is what you're saying? That's good to know. Making note to self. Okay. The IRS kept coming out with new FAQs, new notices, and kept updating, revising, changing. And every time I started to understand what they were saying, it seems like they changed it or revised it or updated it. And there also seems to be some gray areas that we're dealing with. When I reviewed the CARES Act, I figured I'd go back to the source, and I went to the CARES Act. And I tried to reconcile that to the IRS's guidance. Didn't see much of a correlation. I guess my question is, can I rely on the CARES Act if it's different than the IRS's interpretation of it? Or maybe I just don't like the IRS's interpretation. Do I need to rely on theirs? Stuart, what do you say?
So that's a space that I do a lot of my living, if you will, when it comes to this area. Part of the problem becomes one of the Congress, in the best interest, took provisions of the Internal Revenue Code that have nothing to do with the employee retention credit, calculation or determination of the affiliation rules, determination of the employee count. And then they said, okay, gross receipts. What's that definition? Use this section of the Internal Revenue Code. And ladies and gentlemen, it doesn't always blend, and candidly, it doesn't blend perfectly. And there are some issues. And then the problem becomes one of, well, what is the typical IRS agent going to look at when he does that? Well, I don't know how many of you have ever had to deal with the government, but I will tell you this. It's become almost pretty much taken for granted that the IRS agents look at the manual for their guidance. So I'm not suggesting they've thrown out completely the Internal Revenue Code, but that's what they look for. That's why I mentioned before, and Tom, you know this from the CI side, they want to know what the protocol is, not only on the procedural, but on the substantive side. So the question becomes is, what do you do with all this gray area? And there's a lot of gray area. Partial suspension, calculation of affiliation. You got to at least make sure that there is a reasonable basis for it. One place that we've seen that, which is kind of interesting, which is on the partial suspension side. You know, what does guidance mean? Well, and I've had numerous calls with the IRS, and they say what we put in the writing, and what we put in the notices, and the notices say it has to be a mandate. A mandate means you have to be prohibited from doing certain things. And then the question becomes, what does prohibited mean? Well, guess what? If an IRS person asks you, okay, what's the definition of prohibited? It means you can't do it. So how did you prove that you couldn't do it in certain contexts? Again, ladies and gentlemen, don't get me wrong. It is possible and it's practical to, in fact, qualify for the ERC in the healthcare space. But you got to make sure that the basis upon which it's done is solid. That's really the point more than anything else. And as we go through the 5 years and the extended statute of limitation periods, the IRS tends to go much, much more conservative. And I've seen that already over the last sequence of calls. That there are two people that are primarily responsible for issuing the notices. And when they started doing this back in April of 2020, and compared to what they put out, let alone what they say on the phone, even though their first caveat is you can't rely on anything we're saying, they still tended to go much, much more conservative. So
that makes sense. Thank you. So maybe I guess what you're saying is some of these cases are more complicated than others, and there's a chance I get audited. The agent might not agree with my methodology because that's not what the Internal Revenue Manual says, but I might have a very reasonable basis, and I might need to go to appeals in order to get somebody with a little more common sense to review this and weigh in on this. And a lot of it's just managing client expectations, letting you guys know, we think you have a good position, but don't be surprised if it gets denied at that first level because the agent's not really sure what they're looking about. And your facts don't fit nicely into this box. Doesn't mean that you need to give the money back because your audit didn't go your way. It just means it's going to be a little bit of a longer haul.
Sadly, I mean, and a lot of people will tie, right now what's out there, the FAQs and things like that. And those are only as good as till the time the IRS changes them or revises them. They're not laws, they're not regs, they're nothing. Just other IRS interpretations. So when you look through it and you're trying to put your circumstance or scenarios, unless it fits right into the example they use, a lot of this is sort of, let's think, like Seth had said, review the CARES Act, review whatever's out there we can do. But the FAQs are just that. FAQs that they created based on, however, sometimes they inquire of professionals and things of that nature, but it's just FAQs and they change. And if you look back and, you know, just recalling back the old offshore bank cases and they came out, the offshore voluntary disclosure and program where they were laying out FAQs, and every couple of months they updated them or added to them as they began to see and experience issues or soft spots, so to speak, in the way that they examine or review these things. They'd add a new FAQ. So again, relying on them is maybe the only thing we have other than the statute. And like Seth said, you may have to take a position. You may have to litigate. It may mean going to appeals, even going to tax court if you have to, if you think your position is that good and it makes sense financially.
Right. And what makes it more interesting is looking through the FAQs and the notices. Some of it is just a safe harbor. Some of it is not actual directive. Some of it's guidance. You really need to know, all right, is this a safe harbor or not? Maybe I don't want to fall in the safe harbor. Maybe I'll be a little more aggressive. But, okay. We were talking before about IRS audits and request for information and Covell privilege and all that. So I just received my first IDR, my information document request. Line number 1 says they want all tax work papers, all correspondence, all accounting, all legal professional work papers, all opinions, all memorandums, anything related to the calculation of the credit. Now, to be honest, we had one accountant who reviewed our financials, and he said we don't qualify for the ERC. So obviously, we got a second opinion. we got a second opinion, and even with this new accountant, we had to go through a couple rounds until we finally agreed upon a number that we were going to use. That final number matches the tax return. Could I just use that final work paper and forget everything that came before it? Ahron, what do you say?
As a good friend of mine, Seth Kossman, once told me, an IDR, which is a document request, is just a request. That's the first step. Just like in business and negotiation, no is just the first step, first part of negotiation. So just because you get a document request doesn't mean you just, okay, the IRS said something, turn it all over. Obviously, you want to take a look at what the law is, speak it over with an attorney that has experience to know. But as a general rule, the courts have stated that not all tax opinions are created equal. You have to take a look at a tax opinion. I will tell you that my firm has issued a bunch of tax opinions in the ERTC space, and we feel very comfortable with it. We feel very comfortable that if this ever came to an audit, that's something that an IRS auditor, which is reasonable, which is not necessarily, going to happen. But if somebody is reasonable, would take a look at it and see how the FAQs, any guidance, any law, the examples, the facts on the ground, with all the government mandates, are all there in the opinion. It's not just a wishy-washy opinion. It's something where it's clear, given all of the facts and circumstances when put together. It's an opinion whether something could be taken, not just, well, if you feel that you're eligible, then you should feel comfortable taking the credit. That's sort of like Google. It's not much of an opinion, but I think, you take a look at the different tax opinions, and the courts will want to see something where the person writing the opinion, aside from having the credentials, took a look at both sides of the matter, as not just writing an advocacy piece. So, I feel totally comfortable backing any opinion that I wrote to say that those people qualified.
Well, at least one person gets to sleep so far. So.
See, I'd say along those lines, what I've mentioned to Ahron is a document request is a document request. Determine what you want to give, as long as you're not misleading. You can't tell the IRS, this is the only opinion we have, and here it is. If you've got 5 other previous ones, but you work around it. Just a insider tip, another one I haven't shared with you yet. Many times you see documents from attorneys and accountants, and there's a version number on the bottom of the documents. This is document 123.6. When you do that and the IRS gets that, they're obviously asking, can we also have 1 through 5? So when I give clients final documents, I take off that last digit because it's nobody's business how many versions we had to go through till we get to it. But that's just a roadmap from the very easy low-hanging fruit.
I think the point of this is that you can't mislead. You can't lie. You can't make it up. And you've got to avoid those direct questions that lead them to, seek the documents that maybe they didn't know about. But just be careful, because anything you say in a civil matter can still be used in any other future matters, as far as if it goes into a fraud area. So be careful about what you provide, and with your professionals, determine what it is that you're going to turn over. Usually let them do it, and make sure that you're just giving righteous, good stuff to them without creating anything or lying.
Just another practical tip. You might not want to have the same attorney representing you who did the first go-arounds. So if the accountant attorney who's representing you on the audit is the one who did the original opinion, they have some skin in the game, you might want to have somebody new, and especially like Ahron, who throws everybody under the bus. You might want to end up throwing that first person under the bus. So it's never good to be first in line. All right. I received a huge refund check from the Employee Retention Credit from the IRS, just when I needed it most. It literally helped save my business. And after listening to you guys talk today, I'm having some second thoughts, and maybe I asked for a little bit too much, or maybe I didn't really qualify at all. Can I just give the money back to the IRS, no harm, no foul, and just not want to go through audit, not want to deal with criminal investigation, return to sender? Tom?
So, Seth, you go and you rob a bank, okay? And then you run out the door and realize there's a dye pack in it, and you don't want to get blasted with neon green paint, like an airbag going off. And you say, you know what? I'm going to just go back in and give it back.
Second thought.
I didn't really want to do this. You still robbed the bank, right? It's the way the IRS will look at it. But it's not as simple as that. It's not the greatest analogy, because one of the things in the advocacy world and controversy world is that oftentimes we have to shine the light on the IRS before the IRS shines the light on us. And so you have an opportunity to correct things when you've made a mistake, right? Amended returns are there for a reason. Why you want to change it, why you maybe want to give it back, and the underlying stuff that you submitted could be considered by the IRS to go towards the intent of what you tried to do. Usually, you hire a professional and they'll say, well, we got to talk about the underlying facts, and let's figure out what was going on. And if that claim was based on fraud, you have now a serious issue, because the IRS would take the position that anything that you change now at this point could be used against you as an admission that what you did in the first place was fraudulent, perhaps. So you have to figure out the method to get in. I mean, making the corrections are a good thing. It's how you get in, and whether or not you just file your amended returns and just kind of silently go away, a silent disclosure. That may be one way to do it. Or if, in the opinion of the professionals that are helping you out, there was some fraud behind this, and you just got you felt guilty and wanted to give it back, you may need to go and get some additional protection through a voluntary disclosure, perhaps, that's formalized, where the IRS says, all right, we didn't know about this, and we thank you for giving us this information, and while we won't guarantee you immunity, we'll factor it into whether or not we recommend prosecution. So it's a lukewarm sort of letter, but the IRS gives those out, and I've never seen a situation where somebody in earnest went into the program and then the IRS turned around and prosecuted them for what they eventually turned over. So you get a little bit of security in the sense, hey, I'm going to be protected, even though I could have committed fraud, and that's the point. And in the past, it maybe people went in just because they wanted the protection. Now the IRS says, you know, we want to make sure you committed fraud before you go in. This is a program for fraudsters to come clean, because there's some significant penalty framework set up for the voluntary disclosure. So you have to kind of consider, Seth, where your mindset was, what your accountant was doing at the time, what your lawyers were thinking, and consider that when you make the decision to get back in.
And don't forget, that opens up a whole panoply of questions from the IRS, which was, what were you thinking? I mean, I've had situations recently where people have asked us to look behind and to see if they're getting a little bit uncomfortable. And I said to them up front, I said, if I'm going to tell you things you don't want to hear, what are you going to do then? Are you going to give it back? I don't know, but I'd rather be more informed. So I said, so why did you go ahead and do it to begin with? And this was the response, because everybody else did it. Okay? Listen, at the end of the day, nothing is free in this world. That does not mean you can't qualify. It does not mean legitimately that you don't have a good basis for it. The problem becomes one is that where do you balance the two out, and how comfortable are you? And that's something that you really have to think about very, very carefully. And did you really analyze things because in your haste, because you really needed the funds, did it make sense or not?
Well, Tom, you keep saying fraud, and fraud to me is the F word. None of my clients have fraud. We get around it. We don't go there. Yeah. All right. I took the ERC, and I have no problem sleeping at night like these other guys. I'm sleeping just fine. But at the same time, it probably makes sense for me to prepare for an audit just in case one eventually comes. Anything I could do now after I've already claimed the ERC? Stuart?
So one of the things is the fact we've come up with some alternative analysis, which is a little bit different way to view different the affiliation rules, the employee count, and things of that sort. And part of it's based upon discussions we've had with Uncle Sam. But also the fact is, for those who have done it, the real question becomes, did you really capture all of the data that you really would need? And you need seasoned folks that have dealt with the IRS to, in essence, help develop that audit, protectionary device. And what that really consists of is a thorough development of the facts, because all of this is driven by the facts, but it's also in terms of the restrictions from the various states. And that's really where you get the issue, which is because when the CDC, which is pretty much what a lot of the rules seem to have been based upon, CDC does not tell you it has to be this way. CDC is guidance. And that's which opens up a whole lot of inquiry about what does the guidance mean. But the IRS has told us, and the IRS put in print, that it's got to be things that prohibit. It has to be a restriction. And that's why on the nominal side, they have basically said that it has to be a restriction on the operation. And you got to be able to show that. And there are ways to show it. So to really bring to the forefront, the question becomes one of how comfortable are people with what they did, and also number two is that if there are other alternative analyses that could be done to better buttress the claim, because even if you have to give it back, you don't want to have to deal with the bad penalties and things of that sort. The other problem is that it's a lot of money, coupled with the fact is who says you're going to have that same amount of money later on, because you could be several years down the pike. So
We have clients who literally have the uncashed refund checks sitting in drawers in their office, still debating whether they should cash it or not.
And we didn't know this when they hired us. They said, we just wanted to get some ideas. So now they said, can we deposit the check?
We're like,
Guy
look-
was holding $15 million in the form of 3 checks.
Okay, well, thank you. Tom,
And yes,
any
he was able to sleep.
parting words?
Well, to your last point, I think that in my experience in dealing with this type of area of accounting and dealing with the IRS, you've got to be prepared. I mean, it's really the preparation thing. I think so many things happen negatively when you're not prepared. And that means making sure that your files are accessible and to everything that Stuart had said. So it's very important that you think about it from a risk-based perspective, and there's a risk you're going to get audited, and make sure you'll be able to defend your positions to the best of your ability. And that's, I think, the best advice I could give anybody at this point. But thank you very much for the opportunity.
Stuart, any concluding thoughts?
No, listen, at the end of the day, nobody really knows exactly when the IRS will begin the process. They have had, the longer it takes for them to review a case. Now, granted, right now, a lot of questions, clients are asking us, if I file today, what's the reasonable expectation for them to, in fact, process it? They're now running somewhere between 6 to 7 months behind. And that's part of it is because once it goes into that, what they call, the second analysis, which is they call it the fraud analysis, that's usually a 3 to 4 month period. Once it comes out, so and not only that is, but now nobody's really quite sure because historically in the past, the IRS has had several groups all around the United States. The only thing they did was process ERCs. Now the question is how many of those are going to get reassigned to work tax returns? So
Great.
it really it's something to think about.
Thank you. Ahron?
There's the old story about the 2 people that were being chased by a bear, and they say you don't have to run faster than the bear, you just have to run faster than your friend. Don't do anything just because everybody else is doing it. I was speaking to many people before a recent healthcare conference, and they were really on the fence about taking it. And then they went to this conference, you're probably all familiar with what it was, and they all came back and they said, yeah, everybody's taking it. It's gone. As long as I run faster than my friend, there's safety in numbers, no problem. I think, one of the things that I think about is this is very fact specific. If you don't have the numbers, the drop in gross receipts, which is a clear-cut thing, you just have, you're relying on this partial suspension, take a look at your facts and circumstances because not every situation is the same. And therefore, if there's one thing that COVID has taught us is we don't really know anything. We don't know what's coming tomorrow. So therefore, just take the time to be able to look at your specific facts and circumstances, have an unbiased person that is reasonable take a look at it. And by all means, if the money is valid, take it. Don't leave it on the table.
Great. Thank you all. I found this very informative. I think next year we might have a lot more anecdotal stories, case law, some internal revenue guidance of how things are going to be viewed, maybe some press releases of people who are behind bars. But thank you all for your time today. If you have any questions, our panelists have agreed to give up the next day or two of their life to answer it. Thank you.
Thank you.